Thanks for letting me talk about this strange subject. I was desperate to find something that would count as a school of legal thought in the United States until it occurred to me that we have this pervasive, continuous American legal realism about which no one ever thinks very much, no one says very much anymore, but it is everywhere. It's not acceptable in polite circles to dismiss it or to say that it's no longer relevant. So I want to talk about where it came from and how it persists, because it has kept its vitality of a very strange variety for now quite a few years. I'm going to call it a school of thought, even though it doesn't have a clear body of beliefs. There are no basic tenets by which one would be tested to determine whether one is an American legal realism and a realist. But there are a few, well, you can call them beliefs. I will call them that for the moment. Two main points that unify the movement, and one is that law does not require conceptual analysis of legal rules. That, of course, implies that legal methodology is not necessary, doesn't really have any content. And the other is that law's content must and does automatically reflect social evolution. Let me just throw in that the word realism in English has several different informal connotations, one of which is, if one is a realist, one sees the world as it really is. Realism in the sense of really is. But another is the connotation that if one is a realist, then one doesn't worry about theory. One gets real. Let's just get down to it. Let's come to grips with things in a very pragmatic way. And I really think that those two connotations of the word realism have played a bigger role in selling the idea of American legal realism than any others have. I also want to talk a little about this movement's links with legal positivism and with the rejection of specific forms of legal methodology. I mean, I've just said already that American legal realism doesn't seem to see the need for rule analysis because it's skeptical about the very existence of rules. But there is some more specific content in the movement in attitudes towards aspects of legal methodology. And let me just say here that, well, I'll go on about this in a moment. In the United States, of course, since we're not a country that has a legal code, legal methodology might conceivably, and probably does, have very different connotations in different areas of the law. So there may be or may not be methodology in, say, tax law or in the law of the basic areas of common law, such as tort, negligence, contract law, criminal law, and so forth. Criminal law, of course, also was originally common law. So finally, just to complete my overview of American legal realism, I'm going to say that it has the emotional feel of a movement, but the feeling is that we still just have to be practical. So really, it is a form of pragmatism, I'd say. And that much is still very strongly felt among lawyers in the U.S. today. Since we are mostly legal educators or students of law here, I'm going to go back to the beginning of this movement and talk about its connection with the early days of education in the United States. Long ago, around 1880, the founders of U.S. legal education spread the idea that legal teaching, of legal teaching by discussing judicial opinions in decided cases. Now, of course, the United States was then still very dominantly a country with the common law, inherited from Great Britain, and in large part at that time still not distinct in any way from the common law of Great Britain. So these founders of U.S. legal education were essentially saying, we are common lawyers, and so we have to look very carefully at the earlier decisions when a new issue arises, which a court must decide today. So precedent, earlier decisions, commanded the attention and concentrated analysis of common lawyers of the least intellectual variety. The founders of U.S. legal education were trying to gain respect and credibility with practicing lawyers by saying, yes, that's what we're going to talk about as well. We're going to look at precedent and analyze it closely. And the first few who took that position were among the founders of the first university faculties that taught law, of which easily the most important one at the time was the Harvard Law School, brand new Harvard Law School. But after the first generation of legal educators had emphasized this formalism being concentration on legal precedent, analysis of rules of the past, almost immediately a new generation arose. These were people also teaching at Harvard Law School, Oliver Wendell Holmes Jr. and John Chipman Gray, who were radically skeptical of the first of all, of the need for that type of analysis, but their reasons for being skeptical had to do with skepticism about the very existence of rules or holdings of any survival value in earlier decisions. The most important and famous formulation of that view is found in Oliver Wendell Holmes' essay called The Path of the Law, in which he says that the law is nothing more than the bad man can get away with. So the reasons given by courts for stating the law to be this, that, or something else don't really matter. All that matters are what, in the lingo of American courts, we would call the results, that is, the outcome in a particular case, not the holding, which would be the legal reasoning on which that result is based. So everyone understood Holmes to be saying, forget the content of these opinions that the common law judges are writing. They're not important. John Chipman Gray went a step further and formulated this very clearly in the 6th chapter of his book on the nature of the law, essentially denying the existence of rules. Now, what this gave rise to initially was not really a new school of thought, so much as it was a vanguard of offense to the earlier generation of legal methodologists at least in the United States. In order to understand quite why that was so easily transformed into a movement, I have to mention that the Constitution of the United States leaves to the member states alone and doesn't allow the federal government nor the federal courts any role at all in determining the basic content of what we would all think of as the core of any legal system. The law of torts, délit, the law of contracts, some aspects of criminal law, and many procedural rules. All of these were and are still today the law of the individual U.S. states. The federal government doesn't legislate about these things, the Constitution does not give Congress the power to legislate about these matters. And so they are really still the rules of now 50 separate jurisdictions, which do not have to respect each other's rules. The diversity that's involved in that is incredible. It turns out, of course, that there's a great deal of agreement from state to state, but that isn't required by the authority of the federal government or by that of the states either. Why am I going on about this? Well, the early educators in law really did hope to help unify those aspects, diverse aspects, of the law of the individual states. That's one of the reasons why formalism seemed to be a good selling point for legal education. You might be educated at Harvard in Massachusetts, but you could go to New York State, and what you had learned at Harvard would make sense in terms of New York law as well. That was a very practical thing for them to believe. Very soon, though, shortly after, when Holmes and Gray made their striking points, there were, of course, other important early American legal realists, whom I'll mention later on. Soon, most law professors in these new law schools had adopted the same skepticism about rules, about the importance of analyzing rules, and about the importance of coherent methodology in the law. And lower court judges also openly professed their belief in American legal realism. Now, at that time, we're now talking about the late 1890s through roughly, well, I'd have to say, I'd have to go as late as 1939, really, but it's mostly the 1890s, the first 2 decades of the 20th century. During that period of time, something else was happening that influenced the spread of American legal realism, and that was a retreat from the relatively conservative approach that federal courts had taken in squelching and invalidating local law that created new rights for workers, for, even for that matter, normal contracting entrepreneurs and others, in order to accommodate the new world of the 20th century. The older federal courts had been, especially the Supreme Court, had decided no constitutional issues other than those under what we still call the Contracts Clause, and the U.S. Supreme Court invalidated almost all local law that was adopted during that period. So many law professors and lower court judges resisted this by denying that there was any such thing as a core of methodological procedure to be handed down by the federal courts, by the Supreme Court to the lower federal courts, and by the lower federal courts to state courts. So what did the new realists believe? They thought courts should consider a broader range of information than the facts of the individual case. In that sense, they should be realistic, should be open to the world. And they should be more pragmatic than methodological. Pragmatic in the sense that they look at the problem in front of them, decide how to handle it, and not worry too much about what had gone before. Now, this has something to do, it clearly had something to do for those original founders with legal positivism. And I'll say no more than this. One of the core elements of legal positivism, formulated first by John Austin, later reformulated by H.L.A. Hart, was skepticism about the content of the need for substantive rules of law in order to distinguish genuine legal systems from counterfeit ones, from phony legal systems, like those of, let's say, autocrats who really didn't allow courts or lawyers to follow their own instincts. Instead, the positivists thought that purely factual criteria will allow us to distinguish genuine from other legal systems. So legal positivism seemed in a way to reinforce the skepticism that the legal realists had concerning the importance and the existence of rules. So in practice, since that time, ALR has distracted the U.S. legal community from analyzing rules, even though all U.S. lawyers do that, must do that in practice because of the nature of the common law. We have, in other words, a kind of schizophrenia between the theory of the law and what's actually going on. The common law of the US is less self-conscious as a result than the common law of Great Britain, Canada, and the common law's other homelands. So where are we today? First, I'm going to throw in a mention here of critical legal studies. That is, of course, a more recent movement, and you might think it's one that replaced American legal realism, but actually it adopted and exaggerated many of the positions, the ones I've described, that were constitutive of American legal realism. Today, a current generation of legal philosophers, Brian Leiter, Scott Shapiro, Andre Marmor, and others, they do express doubts about ALR, but they don't reject rule skepticism and pragmatism, its key elements. So in a sense, they are deferential towards the content, the original content of this movement. The consequences are that we have an inarticulate grasp of how legal rules work. We really don't talk about them in any context other than practical decisions of individual cases. There's also no academic literature coming from the universities, coming from departments like my law school at Connecticut, on substantive legal issues. Let me be more blunt. I mean, I myself have written articles on substantive legal issues, and the law reviews won't accept them. They're not considered to be what we should be doing. We should be sociologists, psychologists, economists, talking about things that might be relevant to the law, but not about what the law actually is. So there is an unreflective sharing of legal concepts, intention, consent, strict liability among areas of law that we don't even discuss. Now let me throw out there some opinions that have recently been expressed by really eminent judges in the United States. In 1992, Judge Harry Edwards, who is still on the District of Columbia Circuit Court of Appeals, one of the most important courts under the U.S. Supreme Court, wrote a blasting article against legal scholarship, saying that there's a proliferation in this scholarship that does not aim to serve the profession of law. It's not helpful to judges. It's not helpful to practitioners. Judge Dennis Jacobs, around the same time, said, I haven't opened a law review in years. No one speaks of them. No one relies on them. And just recently, the new U.S. Supreme Court Chief Justice, John Roberts, said that what the Academy is doing, that he means law schools, as far as I can tell, is largely of no use or interest to people who actually practice law. And by the way, these detractors of American legal realism do not belong to the same political party. Of course, Roberts is a conservative, but Harry Edwards would have been a liberal. So these are representatives of the judiciary who think they're also speaking for practicing lawyers, and they find that what we academics are doing is of no importance. So where do I come out? ALR, I'd say, still very much alive. It's still felt both in the courts and in the legal academy, despite those detractions by the judges I just mentioned. Its persistence is perhaps due to inertia, and also to its past influence on both these spheres of legal thought. But I would really say my concluding line is that American legal realism bolsters legal thought by leaving the playing field bare. That is a positive thing. It is still promoting realism in that sense. Don't be deterred from considering something yet unheard of by the fact that earlier decisions didn't mention it. But it also discourages reflection on substantive law and on the nature of law. I'll leave it at that. Thank you.